Is that your bag there on the ground? Yeah, it's mine.
I do not consent to this search. Am I being detained, or am I free to go?
It says the authority can't conduct unreasonable searches. You're standing on the sidewalk outside a coffee shop. An officer approaches. Mind if I take a look in your bag? 4 seconds pass. The words you say or don't say in those 4 seconds will decide whether what happens next is legal, or whether it becomes the reason a prosecutor's case falls apart. I've spent 2 decades watching people make this exact decision wrong. And I want to show you what the right move actually sounds like, and more importantly, why it matters. Let's talk about what's really happening inside a police officer's mind when they ask that question. Most people think a cop asking, "Can I search your bag?" is the same as a cop having the right to search your bag. It isn't. Not even close. The officer is testing. They're fishing. And the fishing only works if you say yes. Here's the gap in how most people understand the Fourth Amendment. The Constitution doesn't say you have a right to privacy. It says the government can't conduct unreasonable searches. And what makes a search reasonable? A warrant or consent, or a handful of narrow exceptions, like a search incident to lawful arrest, or when an officer has probable cause to believe a crime is happening right in front of them. But a random sidewalk encounter, an officer just asking to peek in your bag while you're standing there minding your own business, that's not one of the exceptions. That's a fishing expedition, and it only succeeds if you volunteer. This is where people stumble. They think no is rude. They think refusing looks suspicious. They think an officer asking means an officer has a right. None of that is true. But the fear is real, and so is the confusion. So let me walk you through what happens next when you get that question. And I'm going to show you this from the body cam footage. That would exist if this played out on a street corner near you.
The officer.
The officer is standing there. Your bag is slung over your shoulder. It's a Tuesday. Nothing's happening. And then, "Hey, I noticed you walking around the neighborhood. Mind if I look in your time? Mind if I look in your bag real quick?" Notice the framing, "mind if I." That's phrased as a request, not a demand. That's intentional. Because if an officer demanded a search without a warrant or probable cause, you'd know immediately that something illegal was happening. But a request, a polite question, that's where most people's instinct is to be accommodating. Here's where the law gets interesting. And here's where you need to be crystal clear on what's actually at stake. In the 1970s, the Supreme Court case Terry v. Ohio established that a police officer can stop you and pat down the outside of your clothing if they have reasonable suspicion that you're engaged in criminal activity. But Terry also set limits. That pat-down is supposed to be a limited search, a quick check for weapons. It's not an invitation to dig through your pockets or your bag, and it's not a fishing expedition. Then, in 2014, the Supreme Court handed down Riley v. California. That case was about cell phones, but the principle echoes outward. The more intrusive a search, the more justification an officer needs. Your bag is more intrusive than your outer clothing. Your bag contains intimate details about your life, your medications, your documents, your possessions. The law recognizes that,
Correct.
and the law says that without a warrant or genuine probable cause, that bag is off limits. But here's the thing that trips people up. The officer is betting you don't know that. So the officer asks, and because the question sounds polite, because you've been trained to cooperate with authority, because you're worried that saying no makes you look guilty, you say yes, or you hesitate, or you say something like, "I guess so," which the officer will interpret as consent. And the moment you say yes, the legal protection evaporates. Because now it's consensual. The officer didn't need a warrant. They didn't need probable cause. They just needed your yes. This is why those 4 words matter more than you think. Let me rewind and show you what actually happens if you get this right. The officer approaches. Hey, I noticed you walking around the neighborhood. Mind if I look in your bag real quick? And you say, I don't consent to searches. 4 words. Not defensive, not hostile, not. Am I being detained? That's a different question for a different moment. Just a clear statement of your constitutional boundary. What happens next is important. The officer might push back. Well, I'm just going to take a quick look. They're bluffing if they search without consent and without a warrant or probable cause. Anything they find is inadmissible in court. The exclusionary rule grounded in the Fourth Amendment itself. Ask what you're hiding. Nothing to do with you.
Yeah.
Innocent people refuse searches. Guilty people refuse searches. The refusal is a right, not an admission. Tell you they can search anyway. Again, they're testing without a warrant, probable cause, or consent. If they do, that's an illegal search, and a defense attorney will file a motion to suppress, ask you to empty your pockets anyway. You can refuse. If they physically force the issue, that's another matter. You're not obligated to physically resist an officer, but you're also not obligated to cooperate with an illegal search. You say no, and you document it. The key point is this: saying, I don't consent to searches doesn't make you look guilty. It makes you look like someone who knows their rights. And in the eyes of the law, that's exactly what you are. Now, here's something critical that separates understanding the law from understanding how it actually works in the street. An officer might have probable cause that you're committing a crime right in front of them. They smell marijuana coming from your bag. They see you stuffing a stolen phone into it. They have a warrant. In those situations, the consent question becomes moot. They don't need your yes. But in the scenario, we're talking about a random stop, a fishing question, a sidewalk encounter. They do need consent, and they're betting you don't know it. This is where a scenario like this one matters. Imagine you're walking through a neighborhood where there's been some theft. An officer sees you. You fit a vague description. Maybe you're wearing a dark hoodie, or you're carrying a backpack down. The officer has reasonable suspicion that something might be off, so they stop you. They ask questions, and then they ask to search your bag. Now, the officer might have reasonable suspicion to stop you. That's within their authority. But reasonable suspicion doesn't equal consent. It doesn't equal a warrant. It just means they can keep you there and ask questions for a brief period while they figure out whether there's probable cause for an arrest. The search of your bag, that's a different question. And the answer is not without your yes, or a warrant, or probable cause. This is a scenario I'm building from patterns I see over and over in real cases. Not one specific incident, but it's the kind of situation that plays out constantly. And it's one where the vast majority of people get it wrong because they don't know what they're entitled to. So let's talk about what I don't consent to. Searches actually does, legally. First, it creates a clear record. If this encounter is, I don't consent, being recorded on body cam, and many are, your refusal is documented. It's not ambiguous. It's not the officer thought he heard consent. It's clear. You said no. Second, it protects everything in your bag. Because if the officer searches anyway and finds something incriminating, your attorney can file a motion to suppress. And under the exclusionary rule, the rule that says evidence obtained in violation of the Fourth Amendment is inadmissible in court, that evidence gets thrown out. The case might collapse before it even gets to trial. Third, it establishes your credibility. It establishes your credibility in a courtroom. If there's a dispute about whether you consented, your attorney can point to the body cam and say, there's the consent conversation. The defendant clearly refused, and the jury hears that. But here's what most people don't realize. Even if the officer searches anyway, even if they find something, even if you end up charged, your refusal matters. Nafförsmänt of their things. Because your attorney will argue that the search was illegal and the evidence should be suppressed. And if the judge agrees, the case often falls apart. Now, I want to address the fear that's underneath all of this, because it's real and it's worth naming. People don't say no to police because they're worried. They're worried that saying no makes them look suspicious. They're worried that an officer will arrest them anyway. They're worried that they'll escalate the situation. Here's what I tell my clients. Saying, "I don't consent to searches," is not confrontational. I know my rights. You can't touch me. It's a calm, clear statement of a constitutional boundary, and officers hear it all the time. It doesn't escalate a situation. It clarifies it. It clarifies it. And yes, an officer can arrest you anyway, but if they do it based on nothing but your refusal to consent to a search, that arrest is also illegal. And that's another claim your attorney can raise. The point is, your right to refuse doesn't disappear because an officer is bigger than you, or because you're scared, or because you're outnumbered. The right is the right, and knowing it and stating it is how you protect yourself. There's also a practical piece here. About what happens next. You've said, "I don't consent to searches." The officer might then say, "Okay, fine. Are you willing to answer some questions?" Or they might ask for your ID. Or that they might tell you, "You're free to go." Here's where people sometimes get confused and think that refusing a search means refusing everything. You can hand over your ID. You can tell an officer your name. Those are separate decisions from consenting to a search of your person or your property. But, and this is important, you don't have to answer investigative questions. That's your Fifth Amendment, right?
Right.
You can say, "I'm going to exercise my right to remain silent." And then you don't answer questions about where you've been, who you've been with, or what you've been doing. You just answer the basic identification questions if required by law in your state. The point is, refusing a search doesn't mean refusing cooperation with basic identification. It means refusing a search of your body or your bag. Let me bring this back to those 4 words, "I don't consent to searches." Why those 4 words instead of something else? Because they're simple, they're unambiguous, they're not a question. Is this a search which opens the door to the officer, explaining why it's not a search, why they just need a quick look? They're a statement, they're a boundary. Some people say, "I'm exercising my Fourth Amendment right." That works too. Some people say, "I don't consent to any searches of my person or property." That works. The exact wording matters less than the clarity, but "I don't consent to searches" is short, it's memorable, and it does exactly what you need it to do. It stops the fishing expedition before it starts. And here's what happens if you say it and the officer searches anyway. Your attorney gets a motion to suppress. The judge looks at the body cam footage. Your attorney argues the officer had no warrant, no probable cause, and no consent. The search was illegal. The evidence is inadmissible. In many cases, that motion succeeds. The evidence gets thrown out. And suddenly the prosecutor's case is built on nothing. This isn't theoretical. This is how the system actually works, when you know your rights and you invoke them clearly. So here's what I want you to carry with you. The next time an officer asks to search your bag, your phone, your car, your pockets, you have a right to say no. That right comes from the Fourth Amendment. It's real, it's enforceable, and it doesn't make you look guilty. It makes you look like someone who knows that the Constitution protects you and you're going to use it. 4 words. I don't consent to searches. That's the boundary. And everything that happens next depends on whether you say it or whether you fold. Now, what about the moment after you've refused a search? And what if the officer says they're going to detain you while they figure out if they have enough for a warrant? What's the legal line there, and how long can they actually keep you? That's something I want to dive into in the next video, because the answer might surprise you.